individual conscience should be respected in a free society. And that doesn't just apply to a very narrow band of people, that applies to everybody if it's to be truly a free society. So if you say, well, if you work for the public sector, you have no right to conscience, which is essentially what you're saying, then that's not a free society any longer. That is becoming an oppressive society. Freedom of conscience for people working across the public sector is crucial. In fact, if the principle of reasonable accommodation is taken on board, which is what should be taken on board in terms of equality legislation in our courts at Westminster and at Holyrood, and I think there is an opportunity for Holyrood to set an example in this area, but if that principle of reasonable accommodation is taken on board, if you take the example of registrars, you could easily have a situation where a local authority is able to provide a service without imposing on the conscience of any of its staff. That there's no problem in that being facilitated at the local level. The problem is that some people and some organisations want to force people to officiate at same-sex marriages or at same-sex civil partnerships because it's part of an ideological agenda which is being driven. And that will apply not just to civil registrars but right across the public sector, particularly in schools but not exclusively in schools. So that's the question you have to ask yourselves is, do you want to shut off careers in the public sector to people who have a conscientious objection to saying that marriage is between two people of the same sex? I mean, I think there are very weak protections in the bill, to be honest. I think the Scottish Government's intent is probably honourable. I would take them at face value in what they say, but I don't think they've backed it up with legislative support. In a sense, what the Scottish Government have sort of indicated to us informally as well, you know, this is Scotland, everybody knows each other, we're all friends here, nobody's going to do the sorts of things that happen in England. Therefore, we don't need legal protection. It can all be guaranteed by guidance and by a sort of informal agreement with the Registrar General, etc. You know, that's, or the Lord Advocate, that's the approach which the SNP government has taken, and or the Scottish government has taken. So I don't think that's sufficient. I think there are things that the Scottish Parliament can do in terms of legislation to protect charities, for example. You can look at the definition of public benefit, or more significantly the definition of public disbenefit, and you can change the charity legislation so that Oscar can't do to churches what they're doing to St Margaret's Adoption Agency at the moment. You could do things to do with, you could introduce a statutory right for parents to be informed and to withdraw their children if they are uncomfortable with what they're being taught, depending obviously on the age of the child. You could look at, there are other things that you can do under devolved legislation, but equally, I think you've got quite a lot of political clout in terms of influencing the Westminster government, and certainly you could seek to get a stronger agreement for the amendment of the Equality Act from the Westminster government, and that would be, I would encourage you to do that. Indeed, I would draw your attention to what the Faculty of Advocates have said, and I'd encourage you to ask them their views, because they do say that the current agreement which the Scottish Government has come up with is not watertight and could well be challenged, both in terms of chaplains and people working in the public sector, but also in terms of some religious celebrants being forced by their denomination to participate, even if it goes against their conscience. It's good that the committee looks at the issue of the bill in principle at this stage and not just at the details, because part of my fear has been that the whole focus will be on the details. And so the question you have to ask yourselves is, what is marriage? Is marriage just a subjective expression of love between two individuals, or is it more than that? Has it got some sort of objective reality? And in particular, what is the state's interest in legislating for marriage? And it seems to me that over history and throughout societies, the state's interest in legislating for marriage is because it is the context in which children are normally produced and reared, and it is the most stable and secure context. And if you look at the sociological data, you will see that children perform better if they come from a married parent's family than from a single parent family or from some sort of other broken home. So that being the case, I think that the state has an interest, an objective interest in recognising marriage in law and in legislation. In terms of whether or not people love each other, the state has never really been that interested in whether or not a man marrying a woman love each other. What they're interested in is, are they making a commitment to stay together, and are they going to provide a framework in which any children are raised? That is what the state has been interested in.